if the pleadings are completed, then we list it. So in admission hearing only.
Yes, admission on the
Okay,
lordship.
Ms. Sukhi, then additional AG, hearing on behalf of the state respondent with the consent of the other side, praise for listing this matter after
The winter vacation lordship.
winter vacation.
Yes.
Okay,
Mas-
after the ensuing winter vacation. The prayer is now listed accordingly.
Okay, much.
No, not adjourn. It will come.
Perhaps Lordship.
Hmm.
Lordship, I beg to mention item 27. 27, Lordship, for the number 2.
27.
Lordship, let it come up for 2 weeks, Lordship.
Lordship,
Yes.
can you list this matter on after vacation, that's 16th January?
So what do you say? I
Okay,
repeat.
already, Lordship.
On the joint prayer made
27.
for the Lana Council for the parties, list this matter on 16th.
16 January 25.
Okay.
Lordship, there's interim may continue.
Start. The interim order passed earlier shall continue to the next day, till then. Okay.
Perhaps Lordship. Lordship, I beg to mention item number 5, Lordship. And for the petitioner. Lordship, the petitioner is not keeping well, Lordship, and I've been instructed to file in reply, but I need some instructions. So Lordship, may kindly let this matter come up after the vacation, Lordship.
Mr. Oseho for the Lana Council for the petitioner. Praise for some more time. How much time is it?
After vacation, Lordship.
Time for filing affidavit in reply
After the file.
to the affidavit filed by the respondent. The prayer not objected to by the Lana Council. Respondent. Accordingly, the prayer is allowed. List this matter after, it is prayed for, comma, list this matter after the ensuing vacation.
Lordship is an interim. Can you let the interim continue, Lordship?
Stop. Para. The interim of the past earlier shall continue till the next date.
Lordship, similar prayer for item number 3 also, Lordship. You also forget to file affidavit,
We are also.
reply, Lordship.
Reply.
Lordship. Let it come up after the vacation, Lordship.
Okay, same order.
May I please, your lordship?
Similarly, there's an interim, Lordship.
Very
And
much.
I beg to mention item number 3.
Item number 3.
Yes, that may be fixed, Your Honor.
Okay. Date.
After the vacation,
After
any
the-
date is convenience.
16.
Any date, yeah.
16, Lordship, then.
Okay.
16th of
Same
Jan.
order, same order. And you are Mr.?
MK does.
Okay.
Lordship, there's an interim,
There is interim.
Lordship.
Same order as earlier. Okay.
I will oblige, Lordship.
Please, the lordship. Lordship, I beg to mention item number 19 to 20, lordship. Here I am for the state respondent, lordship. 19 to 20. 9 to 20. 9 to 20. Lordship, here the state respondent is yet to file counter, lordship. So if lordship may please to grant another 3 weeks time, lordship.
Not yet filed.
Not
I'm for the petitioner, Lordship.
Okay. Mr. Pacific for the Lana Council for the petitioner is present. Stop. Mr. Jimomi, Lana Council appearing on behalf of the state respondent. Praise for further
3 weeks time, lordship.
3 weeks time to file affidavit of opposition. The prayer is allowed. List this matter after 3 weeks.
Lordship. Oblige, my lord.
Lordship, I have similar prayer for item 21, lordship, on behalf of MS Inaholi, lordship.
21.
Lordship, 21.
Here.
For the petition.
For the petition.
Right.
What do you want here?
Lordship, this notice is complete. Lordship, if this matter can come up after 2 weeks, Lordship.
Okay, Mr. Takaki, to land council for the petitioner is present. So, Mr. Jimon, why land council appearing on behalf of the state respondent prays for listing this matter after 3 weeks, which the land council for the petition has no objection. So they are not accordingly list this matter after 3 weeks. Okay.
Lordship, I have similar prayer for item 24, Lordship. Here, I'm for the state respondent, I'm yet to file my counter, Lordship.
The petitioner is present.
Your Lordship, I'm counsel for the petitioner.
Have not yet filed.
No.
Okay. Mr. Jimon, land council appearing on behalf of the state respondent. Have you filed?
Yes, I filed.
Okay. Praise for father, how much time? 2 weeks time. 3 weeks. No. Time to file affidavit note, or counter affidavit. So the land council for the petitioner.
Lordship, on 22 October, I was directed to take first step upon the private respondent 11. Accordingly, I've taken registered post with AD on 23rd October. Lordship.
Okay. This is with respect of respondent number
11.
11.
Yes, Lordship.
Wait, we'll pass order, we'll see the order. Okay. Office note also, we'll pass order, we'll adjourn, wait, okay.
My pleasure, Lordship. Lordship, I beg to mention item number 8.
Item
Item number 8.
8.
Lordship, kindly grant 3 weeks time to file my affidavit.
Your miss, land council for the petitioner is present. Miss,
Pichano.
land council appearing on the state response,
Lordship,
praise for how much time?
3 weeks time.
Further 3 weeks time. To file counter. Of the prayer is allowed, list this matter after 3 weeks. Okay.
And your worship, I'm for the respondent number 5.
Okay, Mr.
Ari,
Land council for the respondent number
number 5.
5 is also present. Okay. What's it?
Lordship, item number 22, similar prayer on behalf of AIME.
Any objection?
No, Lordship.
You are miss,
Bertatep.
land council for the land council for the petitioner is present. Miss. Her name, land council appearing on behalf of the state respondent, pray for how much time?
3 weeks time,
Further
Lordship.
3 weeks time. To file contract. Prayer allowed, list this matter after 2 weeks. Okay.
Lordship, I also like to beg to mention hearing item number 28 on behalf of AIME. Lordship, kindly list this matter after 1 week.
You are for the petitioner,
Yes, Your Lordship.
no objection.
Yes, Your Lordship.
Okay, miss,
On behalf of AIME.
made a mention on behalf of
AIME,
AIU, land common advocate.
Lordship.
And praise for father,
1 week, Lordship.
1 week, for file, okay. Okay, praise for adjournment of the matter for a week, to which the land council for the petitioner has no objection, prayer allowed, list this matter after a week, okay.
Lordship, item number 29 also. Lordship, if this matter will come up after the vacation. Yes.
No objection, Worship.
You are for the petitioner,
Yes,
no
Lord.
objection,
Yes, yes.
okay, Mr.
Tushidamjan.
Wasitam, then land council for the petitioner is present, miss.
Uh,
Here also you
Pichano.
are mentioning on behalf of,
No, myself, Lordship, Pichano.
okay, channel land council appearing on behalf of the state respondent, praise for listing this matter after the ensuing vacation. Prayer not objected. List this matter after the ensuing vacation accordingly, okay.
Much obliged.
Lordship, I also like to beg to mention supplementary item number 33 on behalf of Tiba. Kindly list this matter after 1 week.
Why? This is to be disposed of,
Lordship, he have some personal difficulties. So if this matter become after 1 week.
We'll get it listed on Monday.
Monday. Lordship,
Okay, as prayed for by. Whether you are for the respondent here,
Lordship, I'm on behalf of DIPA
Tiba is,
for the state, Lordship.
okay, then you have not informed the land council for the petitioner also? Have you informed?
No, Lordship,
Wait for some time then.
Lordship. I pledge.
For motion, item number 1.
Yes, my lord.
Yes,
My lord, this petition has been filed under certain exceptional and extraordinary circumstances, invoking the inherent jurisdiction of this honorable court under section 528 of PNSS, my lord. The issue in this case is, my lord, the benefit of section 428 of CRPC, which states about setting off the period of detention undergone by the convict during investigation, trial, and inquiry has to be set off. But that was not mentioned in the judgment and order passed by the learned district court, lordship. So because of that, my lord, when the convict,
whether appeal lies or.
no, my lord, appeal will not
It
lie.
has to be under 528.
Yes, appeal will not lie. It is just regarding to the setting off period, my lord. Actually, my lord, the
Whether
law is settled.
Respondent need to be informed here.
My lord, since it is a mandatory provision,
You have-
it might not be
we-
necessary, but we have implemented them since that is compulsory. But my lord, it is a settled
Yes.
position of law that 428 provision,
Yes.
the benefit of section 428 has to be given to the convict.
Yes, it appears, prima facie, it appears there is some error.
Yes, my lord.
For the interest of justice, I
Yes, my lord.
let notice be issued in the end.
Notice because probably he is likely to complete by 25.
Yes, and I've been informed that he has earned some remission also. So he
And
might be,
With that, probably he is likely to be released.
yes, my lord.
Hmm.
That is the concern, my lord.
Then what we can do is just you obtain instruction or call for the scanned copy or the record.
Lordship.
And then this may not be.
Issue to the, yes,
the-
yes,
but
I
the
have a
notice will
concern.
Issue, but then we'll not wait for the notice. Also.
Yes, my lord.
We'll issue notice,
Lordship.
but waiting for them would not help.
Yes, my lord.
That probably by mentioning this, where is the operative portion? From this day,
Yes, my lord.
from this day, probably was not required in the judgment,
Yes,
conviction from this day. Then the jail authority probably has counted from that day only.
yes,
But then what about this, the sentence or the custodial remand during the investigation and the trial period?
my
That
lord.
has not been counted.
Yeah, my lord.
That has to be counted.
Yes, my lord. He
Okay.
was arrested on 9/6/15 and never granted bail, my lord.
2015, and this order was passed on, judgment was passed on.
25, 25, my
Yep.
lord,
Yes.
25/7/2017. my lord.
17, then if we count from 17, it will take more,
Yes,
27.
yes, he will be, if set off is not granted, my lord, it will
Hmm.
be injust, it will amount to
And
injustice and
if
wrongful
it appears that
incarceration.
there is some other error. 313 also not done, I think it appears, not mentioned.
So my lord, my learned friend can get instruction and on a short date, maybe can be disposed of, my lord.
Mr.
To show long, my lord.
Procedural long, land counsel for the petitioner. Stop. This is an application filed under section 528 of the BNS S 2023 for setting of the period of detention undergone by the convict during the investigation and trial period provided under the provision of section 428 of CRPC. What is the corresponding
468 of PNS, my lord.
Yes, when you start, you have started mentioning this BNS only, and this should also be 468.
468,
Make it correct.
yes, the corresponding BNS.
Section 468 of BNS. Bracket close, stop. Notice. Returnable by next Monday. Sorry,
Monday, maybe.
Thursday.
Thursday.
Thursday evening. 28.
28, my lord.
Since Mr. Angami, Lana PP accepted notice on behalf of the state respondent, no formal notice need be issued to the said respondent. The petitioner shall take steps upon the respondent number 2 and 3 by a registered post which within 2 days from today.
Yes, my lord. And my lord, the notice regarding the minor, it can be served to the respondent number 2.
No longer minor.
Yes, no longer minor, but my lord, the victim
Hmm.
was minor.
List this matter on 28th. Okay. Just a minute. After issue notice, call for the record. The record would take time, or scan copy, can we?
Can copy also.
It will be a record only.
Yes, yes.
We'll say that, okay, call for the record. Okay.
My lord, if I may, DCR records can be called scan copy, but even also if an instruction can be obtained from the jail authorities regarding as to when he's likely to release if set of period is granted to him, because I've been informed that he has earned some remission also while he was in the
Natural
jail.
remission automatically.
Yes,
Oh. So
I
you
think that is not very necessary if that
because
is set off.
this letter is probably clear.
yes,
The letter of the jail authority
Yes.
is clear. And probably not necessary. Only we'll see the record.
those,
What are
those might not be included in the record. That's my concern, my lord.
okay.
Because the
Then-
report will
then,
be,
before last, that Mr. Angami Lana PP shall also obtain necessary instruction from the jail authority regarding the remission earned by the
convict.
convict.
Yes, ma'am.
And if the remission so earned by the convict is deducted when the accused is likely to be released. Okay. Okay.
Obliged to you. For motion, item number 2.
My please, Lordship.
Yes.
Your Lordship, I have been engaged as the standing counsel for the Department of the CBIC. Your Lordship, I have received some instruction that to withdraw this present appeal, present IA and the petition,
You
Your
have to
Lordship.
satisfy the court or the jurisdiction. Okay, Mr.
Is that cool?
Lana Counsel
Standing counsel for the
or Lana Standing Counsel
for the CBIC. Your Lordship.
for the CBI submit that he has an instruction to withdraw this application along with the and appeal
Appeal petition also.
appeal petition. So the prayer is allowed. This application along with the appeal. Or in the appeal also is this is on being withdrawn.
With liberty to file afresh if
With
so
lib-
advised.
Okay. Okay, then in the beginning, then we instruction to withdraw this so and so so with liberty to file afresh if so advised. Okay. This petition both mentioned both is dismissed on being withdrawn with liberty of praise for come. Stop. Okay.
Much obliged, Lordship.
For admission, item number 4.
Yes.
Your Lordship, till last occasion, it was a report was awaited of the committee. Now that the committee has submitted its report
Hmm.
and it's under consideration by the government, Your Lordship may kindly February 22, February 16, 2024 committee has submitted the report.
Probably this report will cover many other cases.
Many other cases, plus, but more particularly the present petitioners, because they are fixed contingency employees. There are about 24 fixed contingency drivers in the Treasury and Account Department, Your Lordship. So
Now,
Now-
after submission of report, whether this is to be considered again by the government.
government is considering the report. Now, once the government has considered these things, they will come out with a certain notification scheme relating to the matters of the contingency and fixed pay.
Please, your miss.
Sigmo.
Council.
Lordship, let this matter be come up after vacation.
Council for the petition. Staff, Mr. Moore, Land Senior Government Advocate for the state respondent number. I'm told respondent number. Okay. I also have Mr. Moore and Chinnaga, Senior Government Advocate, for respondent number 2. You are for respondent number 1. Okay. Mr. Jimo, for respondent number 1, and Mr. One. Also had Mr. Moore and Senior Government Advocate appearing on behalf of the respondent number 2. Mr. Himchen submits that. The committee was constituted for what?
Lordship committee was constituted for regulation of pay, remuneration, conditions of service
Committee
of
constituted-
contingency and
uh,
fixed pay employees.
Committee constituted for regulation of pay, remuneration, and condition of service, contingency, and fixed paid employee have submitted their report to the government on 18/9/2024, and the same is under examination and consideration of the government, which is likely to take some more time. Therefore, praise for listing this matter after the ensuing vacation. The prayer is allowed. List this matter after the ensuing vacation, on the date to be fixed by the registry. You inform that on that they finalize at least after the vacation.
Lordship.
Sure,
Objection.
sure, sure. My blessed lordship,
Yes,
supplementary item 33.
supplementary,
Item number 33, lordship.
what?
Lordship, I have taken the consent of the petitioner, so if this matter will come up next week, lordship.
Next week,
29, yes. 28 or 29.
Thursday.
Yes.
Okay, let's pray for by both the land council for the part of 33, huh? List this matter on 20 Thursday, huh? Thursday is
28.
28, okay. Okay.
I will let you.
For admission, item number 6.
Please, your lordship. Lordship, here I'm yet to receive the CD. So, your lordship, may I pray this matter be listed after 2 weeks?
After 2 weeks.
Yes, your lordship.
Okay. What happened after obtaining interim?
Anticipatory
will appear before the IO of the case.
Lordship, interestingly, the IO has stopped responding to the petitioner.
Yeah,
Yes,
Lordship,
the
I've
last-
been informed that the
the
IO
last-
is on leave.
Oh.
okay.
Yes, so.
The last conversation they had was the IO informed her because she requested whether it would be possible for her to meet up in Mokchung police station because Tuli is quite far, Lordship. So the IO said that I will get back to you after discussing with my senior officers. After that, there is no response.
Okay.
The petitioner is even
So whenever you communicate with the IO,
yes,
it is always better to just communicate in writing.
yes. So
Okay,
at the
you have
most,
done that.
yes, we have done that, Lordship. This was the previous communication. Even the notice was sent through WhatsApp only to the petitioner, Lordship. So this was the latest. On 27 October, the petitioner have called the IO on 22nd October also, but there is no response. On 27, she called him up again, saying that if it will be possible to make it in the first week of November because she is traveling, Lordship, from 24 to 30. She's traveling to Dubai for a business meeting, Lordship. In fact, I have her ticket also. So, but no response.
The petitioner is cooperating with the IO. He's ready to cooperate.
Yes,
Okay.
Lordship. This is her travel ticket, Lordship. So she's willing to cooperate. But she's traveling on 24th and then on 30th she's returning, Lordship. So if this trip is cancelled, it will cause a lot of financial hardships because she's spending in terms of lakhs for the travel trip, Lordship.
This video goes land council for the petitioner is present. This matter land PP. Praise for some.
2 weeks' time, your lordship.
Okay, praise for further 2 weeks' time to produce the case study. The prayer is allowed. List this matter after 2 weeks. Stop that. In the meantime, in the meantime, the interim order past others will continue. Okay, the next stage.
Lordship, I have a prayer request, Lordship. I have a request that if the IO will examine her during the 24th to 30th of November, Lordship, because she's traveling. She'll be back to India on 30 November, Lordship.
13 after,
After 2 weeks means it will be beyond 30. So
It
by
will be
that time,
beyond 30.
yes. Because today is 19.
okay.
Yeah.
So,
Oh, 90, today is 22, yes, 22. So it will be in the first week of December, your lordship.
okay. So then, 30, no problem, any day
Yeah.
permitted, you
After
can
2
just
weeks.
indicate the IO of the case.
Okay, Lordship. I will inform the
Since you
IO.
are ready to cooperate.
Yes,
fix
Lordship.
Date with IO
Yes.
like this.
Yes, Lordship. I'm awaiting response, in fact, but the IO is not responding, so my hands are tied, Lordship.
Okay.
For orders, item number 23.
Lordship, I'm appearing on behalf of Takakichu for petitioner. Service to respondent number two is complete through substitute manner, and I have filed an affidavit for the same. If this matter could be listed for hearing on the next occasion.
This is criminal petition.
Right, Your Lordship.
How many respondents are there?
One respondent. One is state and the other is private.
This is quasi petition.
Yes, Your Lordship.
What was the allegation just a minute? You are praying for passing of what?
Quashing the proceedings, Lordship.
Sitting
Right.
section? For offense?
Lordship, I'm not well conversed with the facts as I'm only proxy counsel.
No one appears on behalf of the respondent.
And for the state, Your Lordship.
No, the private respondent.
Yes, private
Because it is
respondent.
quasi petition, his appearance is necessary. But it appears that they have taken steps by paper publication. Okay, Mr. You are
James Newman on behalf of Takakichu.
appearing on behalf of Mr. Takakichu, and counsel for the petitioner. Mr. Hughes. The petitioner has taken steps upon the respondent number two by publishing the local newspaper and file affidavit to this effect by annexing the newspaper publication. So, however, no one appears on behalf of the respondent number two. Miss Mary,
Lordship, for the state, Your Lordship.
filing.
Here, state is more or less the pro forma respondent.
Yes, that is.
Yes, yes.
You are not filing anything.
No, no, no.
Okay. Miss Mary Lana is present. Just a minute. There is no any agreement between the party.
No, Lordship.
Okay. You are challenging on merit.
On merit, Your Lordship.
He is the resident of. The respondent is the
Resident of Harolu Colony, Dimapur, Nagaland.
Dimapur. Then it can be tweeted to complete since the paper, there is a paper publication. Miss Mary?
Lordship.
Okay. And there's. Seen the paper publication. Seen the paper publication. Just giving notice to the respondent number two. Wait, have you marked?
I have not marked, but I can assist you, Lordship. Page number 6. Annexure A, page number 6. It's on the right side, somewhere.
Okay. It's not page 6, I think, but this is page, okay. Yes. Right side,
Right side, yes.
this is page 5, isn't it?
Page 5 is the front page and the relevant page is on 6 below. 6 and 8.
6,
Lordship.
it's not there.
Lordship, may I assist?
Please. Okay, giving notice to the respondent number 2, how anyone appears on behalf of the respondent number 2. In view of the notice upon the respondent number 2 is treated to have been completed. List is matter.
Lordship, may it be on 9 December as the main counsel is out of station and she will only be available on 9th.
Okay, when,
9 December.
9 December.
May it on 9 December.
Okay.
And there's an interim, Your Lordship.
Let this matter be listed for admission here on 9 December. Okay. Till then, the interim order pass earlier will continue. Okay.
Much obliged.
For orders, item number 24.
Lordship, as per the direction of this court, I've taken steps on
Yes.
respondent 11.
Miss,
Pikonogisa.
counsel for the petitioner, who submits that she has taken steps upon the respondent number 11. The office note dated 18/11/2024 reflect that the notice upon the respondent number 11 is still awaited. Stop.
I align Jim for respondent number 9 and 10.
Okay, Mr. Jimomi appears on behalf of the status. Okay. You're filing,
I'm yet to file my affidavit.
okay. Appearing on behalf of the state respondent, prays for further 3 weeks time to file affidavit on behalf of the respondent. Stop. Prayer allowed. Miss,
I align Jim
counsel for the respondent number
9 and 10.
9 and 10 is also present, who submits that she has already filed her affidavit. Stop. Come. Is prayed for by the state respondent, come at least matter after 3 weeks. Okay. Right.
For orders, item number 25.
Your pleasure, Your Lordship.
Yes.
My lord, dear, the state respondent number 1 to 3 has filed the affidavit in position. Yes, reply, my lord. And notice upon respondent number 4 is still awaited, my lord.
Yeah.
Yes, my lord. However, my lord, without hearing if the matter is disposed of, it will not cause any injustice to the respondent number 4, my lord.
Who is respondent number 4?
My lord, here, the petitioner has filed on behalf of one minor, Mr. Penry Tangule, and respondent is the mother of the minor, my lord. And this matter is all about pension, my lord.
The pension.
Yes, and whereas the mother, respondent number 4 is remarried to another man after the death of her husband, my lord.
The petitioner is,
Is
who is the petitioner?
the cousin brother of the minor. I filed this writ petition on behalf of one minor, my lord. That is Mr. Penry Tangule, who is
Okay, the minor is
17
paid
years
for
old.
pension
Yes, my lord. My lord,
from the respondent number 1. Okay.
yes, my lord. So here, my lord,
Police department.
Yes, police department, my lord.
Okay, so, the minor is the son of the deceased,
Yes, this is my,
and, the minor's mother has been married to other.
yes, my lord.
Okay.
And my lord, what happened is that while
But
the,
let us wait for some more time.
my lord, dear, the respondent number
Since we have
3,
taken steps,
number 3 was summoned by respondent number 3, and she has
Whereas other
admitted
respondents-
admitted that she has remarried, and also she has filed an affidavit, my lord,
which
before.
one? Respondent number 4,
Yes, my lord.
where?
Here, affidavit before the someone, respondent number 3, here, page number 23 of Annexure G, my lord.
Then where you have included?
Why? Because, my lord, the respondent number 4 has filed a writ petition in her name, and this honorable court has directed to grant pension in her name. However, she was remarried, so she is not eligible to get a pension
Her
as she
already
has
made an
remarried.
application before the concerned authority
Yes, my lord.
that she has remarried.
Yes,
And
my
then
lord.
it has to be
Yes, my
given
lord.
to you.
Yes,
It was not considered.
not considered. Why? Because there
Okay.
is a court order. So the respondent number 3 has,
But till now, she is receiving the pension.
no, my lord. Final pension has not been put up so far, my lord.
Okay. Now you say that
It has not been processed.
the writ
It's yet to,
filed by the respondent number 4
yes, my lord.
was disposed of
Yes, my
by
lord.
saying what?
To grant, actually, my lord, the matter is like this, my lord. The husband of the respondent number 4 was dismissed from service,
Hmm.
and she approached this honorable court to set aside and to quash and set aside the dismissal order and to grant pensionary benefit. So this honorable court has quashed and set aside the dismissal order and has granted pensionary benefits. And thereafter, in the meanwhile, she was married already, and the family has discussed that the pension should be given to the minor, to her child. And accordingly, the minor child has made a succession certificate and made an application before the respondent number 3. However, it was not considered. Why? Because the order was in the name of the respondent number 4. And I'm here before this honorable court to direct the respondent number
Now,
3.
she has to indicate, she has
Yes.
to say that I have no more claim.
Yes.
So.
So, my lord, it's
Because
already,
if the direction is in her name,
yes.
then her response is necessary, her presence is necessary.
So here I have annexed
In her
the,
absence, this court may not be able to pass any order.
so my lord, I have annexed the affidavit which was executed and submitted before the respondent number 2. So that is, I have annexed at page number 23, annex C, my lord.
He has to file in the affidavit form before this court. This we do not know. Court may not like to accept also, unless this is proved. So her response is necessary. Probably it will be difficult because the court direction is in her name.
Yes,
If the
my-
court direction is in her name.
Yes.
So she has to file one small affidavit. I have no objection.
But my
Probably.
lord,
So we can,
this,
because it's not a concern with the department.
yes,
Because
ma'am.
there is already direction in your favor.
But my lord, before the filing of the affidavit, she was summoned by the respondent number 3. So she has admitted before the respondent number 3 also.
Maybe, but then you are claiming basing on the direction of this court. That
Yes.
is why I'm saying.
Yes, ma'am.
And she has to clarify before this court that I have no further claim. Since I'm married to another person,
Yes.
I have no objection if this is granted in favor of the petitioner. He has to say before this court. Okay. Please.
My lord, here I filed this writ petition on 2/7/2024.
Yes, 24.
Yes, but
Not, very-
yes, my lord.
not very old. Okay. Land counsel for the petitioner. Mr.
Elika Sassoon, my lord.
some mistake, he has taken steps upon the respondent number. 1, 2 is, you are appearing.
Yes, my lord, I'm appearing. Lordship, may kindly turn to the common affidavit, your lordship, so that stand up the state. The stand up the state. Lordship, may I read from paragraph 4,
Yeah. What is this?
page 2, paragraph 4. That with regard to the statements made in paragraph 9 of the writ petition, the answering deponent begs to state that the respondent number 3, that is respondent number 3, that is the commandant,
Yes,
wherein the late husband was working,
yes.
has received a copy of the succession certificate and representation dated 25/9/2023 on behalf of Sri Pendritang Lodang Nguli, son of Monglomo Lodang Lotha, from his lawful guardian Sri R. Bobindang Nguli. That is, R. Bobindang Nguli is the petitioner here, the guardian of the minor, for claim and initiation of missionary benefits and other service benefits. However, this Honorable High Court, by its order and WBC number 2221/2019, has granted all pensionary benefits and other service benefits in favor of Mrs. Zopino Lota, the then wife of late Monglomo Lota. And as such, the succession certificate and the representation dated 25/9/2023 was not forwarded by the respondent number 3 to the authorities concerned. That means the respondent number 3 should forward the service benefits to the Director General of Police and accordingly to the Accountant General Office. Lordship, that with regard to the statement made in paragraph 10 of the writ petition, the answering deponent begs to state that Sri R. Popindang Ngoli, the lawful guardian on behalf of Sri Pendritang Ngoli and respondent number 4, wife of late Molomo Lota, was verbally summoned by the respondent number 3 to ascertain their respective stand on the matter and to confirm the claim of missionary benefits and other service benefits by her son, Sri Pendritang Ngoli. It is respectfully stated that the respondent number 4 in the present writ petition has already remarried, and as such, she is not entitled for pensionary and other service benefits. Now that the wife has already been remarried, under whom this court has given the order for pensionary benefit. Lordship, that is the only thing. It is quoted that as per the CCS Pension 2021, chapter so and so, sub rule 2, family pension shall be payable to such widow or widower up to the date of death or remarriage, whichever is earlier. It is respectfully submitted by the answering respondent that Srimati Zupino Lota has already remarried. She is barred by the standing OEM as quoted about to claim for pensionary and other service benefits on behalf of her late husband. Number 6, it is therefore in the backdrop of the above statement in the preceding paragraphs, the answering deponent has no issue whatsoever in regard to the claim of the petitioner to grant pensionary and other service benefits to late Sri Monglomo Lota to his minor son, Sri Pendritang Ngoli, now represented by the petitioner.
Okay.
Lordship, that is the stand of the state.
Okay.
Yes, my lord. The affidavit filed by the state respondent is very clear, my lord.
Otherwise, pensionary benefits could not be proceeded because of this ongoing litigations. Now, first, wife has filed, so this honorable court has given to the wife. Now that the wife has been remarried, she is barred by law to enjoy the pensionary benefits. So now the minor son comes. So that is the only issue,
Yes.
Lordship.
Where is the affidavit relinquishment?
Page number 22, my lord. May I read, my lord?
Yes. So, you have not annexed the original.
No, my lord.
So we can dispose of next week then. We can fix it there. Today is.
Lordship, Lordship.
Hmm.
Otherwise, our state respondents has no issues
No issue. Can be disposed of.
to the claim of the petitioner because we have no issue,
That can be disposed of then.
Lordship, Lordship.
Okay. Mr.
Elika Session, my lord.
And counsel for the petitioner. I have also heard.
Lordship, I'm representing state respondent 1, 2, and 3.
Mr. Mohammed, Lions Union Government Advocate, for appearing on behalf of the respondent number 1, 2, and 2. Then I'll pass over.
Yes.
Okay.
Yes.
Obliged, Lordship.
For hearing, item numbers 30 and 31.
Yeah, please, Your Lordship. Lordship, kindly fix list this matter on December 2,
You're for?
counsel for the petitioner. I've
Petitioner.
also taken the consent of the
Uh,
respondent.
Miss
Ikono Kiso.
Lara Council for. Miss Vikono Kiso, Lara Council for the petitioner. With the consent of the Lara Council for the respondent, praise for listing this matter after,
On December 2.
okay, listing this matter. 2 December, the prayer is allowed, listed accordingly. Okay.
Much obliged.
For hearing, part heard matter, item number 32.
Yes, what is your instruction?
Lordship, the instruction is that my prayer be allowed.
Okay, he has some difficulties, Lordship.
There is a hearing going on at the principal seat.
Okay.
Lordship, can he allow me to complete, because if we start now, my lord, then then they can reply the other day, because they said,
No problem, it appears that he wants to be present.
no, Lordship, it is like this, Lordship, kindly, it will be very unfair, unreasonable. After, when they said they have concluded and they only wanted to reply, and this, my lord, whatever is submitted here, in other days also, before we had these facilities, whoever is here, he's in the case, he'll note it down, and usually the senior counsel comes and replies. And these days it's so convenient that whatever is argued can only be watched afterwards. So, Lordship, because, Lordship, when the matter is fresh in our mind, I must also address it, and also this honorable court also, my lord, when the matter is fresh, Lordship, whatever I say, it is in fact convenient for them to reply on the next date instead of replying today.
Then what we will do is you be here, you are not with the brief.
Lordship, if there's any instruction in any clarification needed by this honorable court from the appellant, they can do it on Monday, my lord.
We'll do
And-
that way.
It is also,
You be there, don't have to participate, but then we'll hear the respondent side. And then if you want to reply,
The government council has also left.
no, the government counsel said, what the government counsel told me, my lord, that since they are going to reply on the next day,
Hmm.
she's not feeling well today.
okay,
So she said, she asked me to request to God, let her, because the appellant is going to reply on the next date, not today, since they are not here. So she'll also make a short submission on the date. Her submission is short. That's what she asked me to.
okay. So
Lordship, what happens is,
16th, we are going to fix another date for hearing on behalf of the government and also for
reply.
the reply of the petitioner. We can just have him hearing. His hearing.
Lordship, what may happen is I'll
So
start
on that day, if there is any further hearing, you can also press, we can also be and
Yes,
give some
yes.
clarification.
yes,
You can do that.
Lordship,
Okay.
otherwise
You
also,
can
my
start.
lord,
I think we can start.
yes, my lord, thank you so much, my lord, because Lordship, if we start today only, then we'll be able to conclude it the
Right,
next
right.
day.
It appears that because it appears the matter is a little lengthy
Lengthy
one.
lengthy one, yes. Lordship, what I have done. Lordship,
Yes. You said you have prepared.
yes,
Because
yes.
this what we could not see it because the petitioner has to assist the court to find out certain documents, certain annexures, certain exhibits. So it will be difficult for court to find it out. And see, it becomes, I think, it's a very old one, 2016.
So
2004.
it started in 2004, trial ended in 2016. Then we filed an appeal. Appeal ended in 2019, my lord, and they filed a second revision this second appeal. See?
Okay. Yes.
Yes, Lordship. Lordship, I thought it could be convenient if I prepare a written argument,
Right.
because like your Lordship says, the record is such. So, and they have prepared a paper book. From the record, they have prepared a paper book, which is admitted by all the parties, both the parties. Now, in my written argument, I've also made the documents that I'm referring to, the page number of the paper books, the paragraphs, I mean, whatever is relevant, I've mentioned. I've tried to assist the court to make it easier for the court.
Okay.
And now what I intend to do, my lord, is that I'll submit this written argument in advance. Then I'll also go through that in sequence.
Right.
So that it will be convenient for your lordship that way.
Yes.
And then lordship, after that, I'll also be placing certain authorities, of which I've also prepared a list of authorities to make it convenient for this honorable court. Then lordship, after that, some submission was submission addressed by the appellant. I'll be dealing with them. Because lordship is the second appeal, but it has been argued like a first appeal.
Yes, of course. And then the fact he has.
Yeah, so therefore now.
Of course, it was necessary also to understand a matter.
All right, man. All right, man. Now, lordship, can I just place the.
Okay.
Lordship, lordship may just keep that written argument. Whenever it is necessary, lordship may look into it.
Okay.
Lordship. What happened is, lordship, this is a second appeal, which is arising of the suit. Initially, the suit was filed before the assistant in the court of the assistant to deputy commissioner. Lordship, before the bifurcation of judiciary, when we had a DC judicial, assistant to DC, under the rules for administration of justice and police in 1937. In 2000, we have a local room framed during the time of Britishers. So that the suit was filed in that court in 2004. In 2006, it got bifurcated, judiciary and executive, and we now have civil judge as per the Civil Court Act. Then, my lord, now the trial was taken up by the Civil Judge Senior Division Dimapur. The court was designated as the Civil Judge, Civil Judge Senior Division. My lord, in that suit, I was defendant number 3. The state and the deputy commissioner 1 and 2. There was one more, defendant number 4. He was also added as the person from whom I purchased the land was also made defendant number 4. He expired during the pendency, but somehow the steps were not taken to impede his legal heirs, and the suit proceeded, lordship.
He was necessary to be implemented.
Actually, yes, lordship, he should have been there. In fact, it was the duty of the plaintiff to bring the legal heir in the suit. That was not done. Then, my lord. Anyway, my lord, we have traveled so far that cannot be a ground for that will not be a ground available to me anymore, saying that a necessary party should have been implemented, and because of its non-implement, that should be defeated. It's too late in the day for me to raise that kind of objection here. Now, lordship. My lord, after that, on 24 8 to August 2016, my lord, the suit was decided in his favor, in favor of the plaintiff. Decree was passed, title was declared, and possession also upheld. Now, lordship, I filed at first appeal before the principal district judge, Dimap.
At the time of filing
Yes.
or before filing, was the suit then under the possession of the?
Yeah. Yes, lordship,
Okay.
yes,
Have you lodged complaint against the
yes,
petition
yes.
before the magistrate?
Before the revenue authority, the collector, deputy commissioner.
Okay. So,
And that's how the dispute. So lordship is like this. My case is, I have purchased this land in 1985. 1985. From the deceased defendant number 4, who was not substituted by his legal heir. And in 1986, I took possession, but I applied for mutation. My lord, is a purchase. So therefore, I don't seek allotment or settlement. The land is transferred in my name, mutation.
the respondent number 4 had already the allotment in his name.
No, at that time, no. It came in, that's why, lordship, I'll go. Respondent, the plaintiff, let's say, the plaintiff. Respondent number 4, lordship. Lordship, in the documents filed by the plaintiff itself, there's a mention that the respondent number 4 was given allotment in the year 1972.
So
But-
whether that document still exists,
It's a part of the records here.
the 1972,
No,
where.
the reference to allotment of 72 is a part of the records here, but allotment to the defendant number 4 by the government is not part of the records.
No,
So I do not know whether it's
that's
exists.
part of the record then?
Lordship, why it has been cancelled?
No, what is the part of the record you just said?
Lordship. Lordship, may I read this?
Yeah.
Yeah, exhibit we had, page 183, no? Yeah, Kiji, what is this? No, this is exhibit. Exhibit, which exhibit is this? An exhibit by the plaintiff, isn't it? Yes, plaintiff's document, right? Huh? P14. Lordship, this is a plaintiff's document, P14. Plaintiff's exhibit in the suit. I'm reading from there. Exhibit P14. This was exhibited by the plaintiff in the suit. And it's a letter dated 9 June 2001. With reference to your letter, this is written to the Deputy Commissioner by the Lordship,
That is 2001 only. After.
Lordship, may I just read this? That's why, Lordship, that's what I'm saying. She is an encroacher. She's cooking up the story.
No,
That's why. I will,
because my question was whether the respondent number 4, from where you have purchased.
yes,
Did he have any document
yes.
of possessing the land, the suit land?
Lordship, I do not know. I purchased the land from him and I've been in occupation.
Now, if you have purchased,
Mm.
and if he doesn't have.
Lordship,
he
that,
doesn't have any allotment,
yes.
how you don't require any allotment?
Lordship, the fact of the matter is, they have to, I'm not the plaintiff here, Lordship. I'm not the plaintiff. I'm a defendant who's in possession of the land.
Now, about your, to know about your right of your possession.
Lordship,
Right?
now they have to
Right of
establish,
possession.
I have to show that
Because you said that, you didn't say, or you say that it was you occupied.
yes,
You only say that purchase from respondent number.
yes, yes.
The only question.
So the question, I'll come to that. I purchased it, I have asked for mutation, my lord, and mutation is given to me because it was recorded in his name, in the other fellow's name,
You purchased the entire land of the respondent number 4?
whatever is mentioned in my pata, because the deputy commissioner, after I purchase, I make an application to the deputy commissioner to transfer the land which was in the name of the seller into my name.
Yeah, that is why I'm saying, to transfer.
Yes,
So whether he had any documents, respondent number 4.
that the revenue court will decide that, no, he did not have the right to sell. It is not my duty. I just take the sell it only, my lord. And if, after checking it, they will check it, they will mutate it, then they'll give me pata. That's the procedure, my lord. I need not prove that that other fellow had the right to sell. If anybody is disputing the sale, then they should challenge it. It's not my duty to come with the document of the purchase, the seller, and that he had right to sell. I apply to the revenue authority who keeps the record. And the revenue authority, after checking it, has given me that has allowed the sale deed was registered, the sale deed was submitted before the revenue authority checked everything, and then they issued me pata after transfer. That's my title. That's the document on the basis I acquired title. Beyond that, how did he acquire the land? That is not mine. Now, but I'm saying, since your lordship has, how did defendant number 4 get it? The person who is not, how did he get it? How did he become the?
Because the claim of plaintiff.
Yes.
Is that he occupied, or he was given this land prior.
Lordship, they have come,
Right,
well, what I'm saying is this is a false story, concordant story, which I will, as we go along, it will be disclosed. This is a false, completely false story, which is, lordship, we are in a suit, it's a trial. Whatever they say has to be proved, lordship. They can plead, they can make up any kind of story, whether that is supported by evidence, that is immaterial. Therefore, have they come and supported their story or their pleadings with evidence?
The Gauhati who allotted land.
That's
to
why.
plaintiff is not- is-
No,
Okay.
and did the Gauhati have the authority to make an allotment? That is also very important, lordship, because Assam land revenue regulation was applicable in the state because this area was under Assam. Even Assam land revenue regulation 1886 is still applicable. It was still applicable then. Gauhati does not have the authority as per law also, my lord, to issue allotment. And they themselves.
It is only the claim of the plaintiff.
Yes.
That Gauhati is given.
Yes.
Then Gauhati
Yes.
never appeared before the court.
Never appeared before the court. There's no, they brought a relative and friend saying that Gauhati has issued. But lordship, I can also bring so many things, so many people. But there's a law, lordship. The law is there. Who is a settlement officer appointed by the government can make allotment?
The friend of the
Yes.
brother of the
Yeah,
plaintiff
and
stated-
lordship, yes.
Stated that I have seen.
I have seen.
Gauhati has given.
Yes, lordship. That he's the only one he said. And then lordship,
Without any corroboration.
no, lordship. No
Nothing.
corroboration, nothing. And lordship, the government also has said in the written statement, though government did not adduce any evidence, the government does not have the right. And lordship, another thing, this is very pertinent. The person who they brought, the friend, and even the plaintiff, appellant, they said Pata system was prevalent in 1968. Since 1968, the land became a cadastral area surveyed. Lordship, what is cadastral surveyed? Is entered into the records of right. Who is holding the land? Those names are entered. So Pata system was introduced in 1968. That is not me saying it. That is the plaintiff themselves saying it. But they did not have Pata. Why they did not have Pata? Because they did not have the land. Lordship, simple as that. And the government, in this letter that I've opened, my lord, I'll read it afterwards. He says in 72, lordship, may kindly kindly note this name. Is the person from whom I bought it is one Hansing. Lordship, this land was allotted by the government to Hansing in 72. This is a document exhibited by the plaintiff. Government letter. And therefore, Hansing's name was in the record. And therefore, it says mutated from Hansing in my Pata. And the government, what they did, my lord, lordship, may kindly.
It was allotted to one Hansing.
That number
Hansing
4?
is nowhere in the case.
No. Hansing is the defendant number 4 who died, but they did not bring the legal heir.
Okay. Hansing is.
Hansing is defendant number 4 in the suit initially.
That is what I'm asking.
That's what I'm saying. Hansing is the defendant number 4
Yes.
in the suit, my lord. When he expires, it is the duty of the plaintiff to bring the legal heir. That was not done. Lordship, in the trial,
That means there are some documents in the name of Hansing.
there's a reference made to it in a document.
Okay, where?
Here, my lord, that's what I'm saying.
Can you just-
Exhibit P14 of the plaintiff.
P14.
Yes, Lordship,
Can you just page?
Lordship, may kindly take page 1. Lordship, the copy given to me is totally not legible. I don't know what about your Lordship's copy. Page 183, Lordship. Lordship, this is not my document. This is a document of the plaintiff.
183.
183. Lordship has found it.
Yes.
Lordship, I think this is dated.
This is 2001.
Yes, Lordship. So here, Lordship, may I kindly see? 2003. This is actually, it should be 2003, Lordship, because in there,
Which one?
yeah, in there, something is referred to as signing must be 2003 because, Lordship, in the plaint, Lordship, in the plaint, it is referred to as 2003, the date. Lordship, may I read this?
Which one? 183.
Page 183.
Is it? This is
It
not
is-
legible. This is not legible.
That is the problem, my lord. All these documents are not legible.
Hmm.
But can I read
Please, please, if you can.
you just read the spot verification, Lordship. This is the spot verification with reference to your letter number such dated 31st May 2003. So this is 2003, Lordship. The date is 2003.
The reference is, okay.
Yeah, this should be 2003. The date is wrong. Yes. Dated 31st May 2003, on the subject cited above, I have the honor to state that the land measuring 1 kata 15 lectures. My lord, my land is 1 kata 15 lectures. Lordship, may kindly remember. Under dock number 172, covered by pattern number 70 of block number 9, was allotted to Sri Chankose Hansing, the person from whom I bought, Lordship.
Let us see the plaint. Let us confirm the name of.
And then, my lord, may kindly read, let me just read the next line also, my lord, while your lordship is at this page. White SDO order number such, dated 31/1/1972, lordship, way back in 72, and issued Jama Bandi. As per revenue record, the same was mutated, my lord. Revenue record says it was mutated and transferred into the name of Sri Apong Pongan. White number such dated 4th December 1985. Apong Pongan is me, my lord, in the revenue record.
How could you read?
Lordship, can I pass the copy which was filed before the first appellate court?
Yes, please. Okay. Do you have that?
Lordship, that will do. I'll manage.
Can't see. Apom is
Apong is me, my lord.
you.
Yes.
This was in transferred in the name of Apom.
Yes.
By dated 4th December 85.
Yes, Lordship. And accordingly, Jama Bandi was issued to me, Lordship. And based on the Jama Bandi, I
So
quit.
this is the document. And this was.
This is exhibited as exhibit P4 by the plaintiff, my lord, not by me, for 14. P14. And Lordship, may kindly see at page 98, page 98, Lordship. Page 98, 8 of the paper book, Lordship. List of exhibit prepared by the trial court, my lord. P14, right? Lordship, page 98. This is the appendix to the trial court judgment. Prepared.
4. Like
14,
before.
14, my lord.
14.
14, Lordship. Spot verification report dated 7/6/2003. So it's 2003.
This is 2003 only.
Yes, Lordship.
No, 2001.
No, Lordship.
But in the document,
Yeah,
it
Lordship,
appears
yeah,
it's
maybe
2001.
the signing is on 2003, below. This was exhibited by the plaintiff, my lord. Plaintiff exhibits. Lordship, a story has been made out, and Lordship, in Dimapur, Lordship, lot of settlement, resettlement exercises goes about. And sometimes the dark, one plot has so many dark numbers. And mischiefs are also occurring. And therefore, my lord, these days, the revenue authority has become very strict. A lot of mischiefs goes on in Dimapur. Because Dimapur is the only place, my lord, where people in Nagaland, where everybody can gather. And so therefore, land is a very scarce commodity.
Okay.
So, Lordship.
So,
So my case is, my lord, I was saying,
whether
yes, Lordship.
the judgment
Yes, Lordship.
of the trial court.
Yes,
whether
Lordship.
this document has been appreciated.
Yes. Lordship, this one.
Yes.
Lordship, the trial court is there. I mean, I do not like to make it. Lordship, some purpose finding is given. For example, my lord, the Supreme Court says revenue records and these documents will not confer title. The trial court says it will confer title. And Lordship, possession also, the trial court also takes notes that I have constructed the brick wall, that evidence is not impeached, it has withstand the cross-examination. Yet, in spite of noting down and discussing about them, suddenly in the finding is a different finding is given. So in similar manner, my lord, conveniently all the materials which is there in my favor or against him ignored.
This document
Yes.
probably is a very important document.
It's a very important document, Lordship.
So this kindly just correct it, compare this and then correct here also in my document also. So because this probably may have to be quoted in the judgment.
Lordship, what I'll do, please note it down. Lordship, can I try to get a type copy?
That will be better, much better.
Page 183, type copy.
Yes.
I'll try, my lord.
Yes.
I'll try my best because I also have that only, my lord. So
Because
from
this
there, I'll
is
try
only
to,
probably the record which is available prior to the,
prior to the dispute.
yes, prior to the dispute.
And then, Lordship,
And then the patta or
after this, my lord.
this was the what I was looking for.
This is,
Now let us confirm that in the plaint.
yes. Have they mentioned about this?
Hmm?
Lordship wants to know whether they have mentioned this in the plaint, right? Lordship?
Yes, yes.
Lordship, can you take,
Let us first confirm the name of the respondent number 4
who expired?
and
Lordship?
3.
Lordship, may kindly come to the additional
Where was
paper book, additional paper book, my lord. Additional paper book at page 4, my lord. Lordship, anyway, my lord, there are so many discrepancies, but we are too late in the day to, I have also not agitated in the trial court.
Yes, yes, it appears.
Yes, Lordship. Lordship, may kindly come to page 4.
Yes, I'll see.
Lordship, Apong Pongon, that is me. Now the respondent number 1, the defendant number 3. Apong Pongon, full name is given. And Chakose Hang Sing.
The Apung name is no.
Apong Pongon is 3, my lord. There is Apong Pongon. Pongon same, my lord. Ao is a tribe. Lordship,
Hmm.
can I also, and this was also, my lord, annexed in the plain, right? This. Lordship, just bear with me for a moment, my lord. Have we that date? 7/6, 7/6, right? 7/7/6/23. 7. Okay. Kuban huruf berapa? 那老师 my colleague, I was submitting. I can leave final answer. I was submitting that, my lord.
Hmm.
Annexure, yeah, annexure side again. Yeah, no. This was annexure. Yes, this was 29 already. No. This is. This was exhibited only, yeah? On. 7/6. 7/6, this is written to the. See, 7/6, no? 7/6, right? Check annexure 14. What is annexure 14 there? 7/6, right? 7/6. This is Lordship, a better copy is also available at page 31 of the paper book, the same document.
31,
31.
the same paper.
Yes, Lordship, I think it's the same paper. Yes, the honor to state that land measuring so. Yes, Lordship. Page 31. Annexure 14. Lordship, this was annexure 14 to the
Yeah,
plain.
this is the same. This is clear.
Yes, Lordship. Annexure 14 to the plain. This is their document, Lordship. I would like to stress this. This is not my document. This is a document of the plaintiff.
No need to type them.
All right.
You purchase land from
From Hansing. In
in the year
1985, Lordship. I am issued Yamabandi. I'm issued is mutated and
your this one
sell it.
sale deed is at page
189. It's dated 1785, Lordship. And then also, my lord, may kindly see.
But see,
Yeah.
this was, this page 31 is in the year 2000?
2003, lordship.
Okay, 2003. Okay. Is this page 31 talking about the same lane?
Yes. And what is, how do, lordship, we go further?
Yes.
Lordship. Then lordship, the salaried lordship is at page 189.
Yes.
Then lordship may kindly come. This salary is registered, appropriately registered, my lord, as per law, before the sub-register, Dimapur. Due stamp duties were paid and registered in accordance. Lordship, their salary was not registered. Lordship, may I pause here for a moment? Their salary was not registered. What the trial court did, my lord, during the trial, which is the basis of their claim, trial court impounded the salary and registered it, asked them to pay the stamp duties. I don't know how much they paid because, lordship, when this process is done, a penalty is there. When the court impounds a document, then asks them to pay the stamp duties, a penalty also has to be imposed. Whether that has been done or not, I don't know, my lord.
In the instant case, it was impounded.
Yes, in the
In the
trial court, my lord, the
trial.
civil judge senior division.
Okay, so
This is the claim they
the
come.
sale deed of the plaintiff.
Send it on the plaintiff, based on which they are claiming.
No, how can it be, the status of the sale deed can be changed?
That's it, my lord. That was done. That was done in the trial. All the way out, trial court has somehow tried to aid the plaintiff.
Now, whatever document being presented before the court, that cannot be changed.
That was changed. And then again, my lord, that is one. Lordship, I'll come to that when we refer to the document again. There's an order here also, my lord. That was done. And he says that also. He says in his judgment also that I pass an order, I impounded it and I asked it to pay the duties, and then I've registered it and I'll take it as an evidence. It's there in the trial judgment.
In
the judgment.
In the judgment.
In the judgment.
Where do we find?
Judgment. Judgment. 75, right? Page 75. Issue number. Yes, okay. Issues from whether having not Where is the document? Okay. Issue number 4 was it? Issue number 4. Lordship may kindly come to page 83. Issue number 4 was this was a issue was also framed on this. Lordship has found page 83 of the paper book. Lordship may kindly come to issue number 4 at the bottom. Whether the document dated 23/11/83, Annexure 1 to the plain is of any probative value and consequently proceed on the basis of this document. We had raised an objection, so this issue was framed. The document dated 23/1/83 exhibited as Exhibit 1 is a sale deed executed between the plaintiff and the original landowner, T. Muri, with regards to the sale of the sued land to the plaintiff for a consideration of rupees 60,000. It's submitted by the learned counsel for D3 that the execution of the document was not proved, unless the document is proved or exhibited by its author or any other person claiming when such document cannot be admitted. He further submitted the plaintiff neither mentioned the two addresses in okay. A personal record showed the sale deed that was impounded and ordered for registration. Yes.
83.
1983, the sale deed, the basis on which the plaintiff claimed that she purchased the land, was impounded, ordered for registration after paying of requisite stamp duty and penalty, and as such, the sale deed is a valid document with probative value. The sale deed had been tendered in evidence by the plaintiff to show that she has purchased the sued land and exhibited as Exhibit P1. The plaintiff has also deposed that the sued land was purchased by her white sale deed dated 23/11. So therefore, my lord, during the trial, it was impounded. The status of the documents was changed, like your lordship has rightly noted.
Just no, it was impounded when?
Lordship, there's an order also to that effect. Lordship, if I may, then there's something here.
So it was not a valid document, but it made it
Made a
a
valid document, yes,
by-
Lordship, by the order of the court.
No, at the time,
Lordship, Lordship, in 2000, there's a certificate, and under, I don't know whether this is part of the record or not, but this is signed by the Civil Judge Senior Division. Certificate under Section 35 of the Stamp Act 1898, dated 20th October 2009, in persons to this course order dated 25/8/2009, entitled Suit 2 of 2004, my lord, this suit. This is to certify that under Section 33 of the Stamp Act, the impounded sale deed unstamped marked as VOS and signed by me on 2010/2009 have sent to the District Collector Dimapur with the above original copy of the said sale deed together with certificate and realized the stamp duty and penalty amounting to rupees 19,340 under subsection 1 of Section 38 Stamp Act. So this was done only in 2009.
where do you find this document?
This is a document, my lord, it should be there in the record.
Not in the,
Lordship, I don't think that is part of the, it is not a part of the evidence in the trial court.
not a part of,
It's not part of
but in
that.
this document,
But he's,
23/11/1983 has been treated as a valid document.
yes. The trial court did treat it as a valid document. Because this was done. In 2009, it was,
This document,
yes.
probably what just we have read is in the record.
It should be there. Should be there. Should be there in the record of the trial court. My lord, even all this, even all this, with all these discrepancies, even I'm saying, this is also not the main ground. This is also not fatal, let's say. Because, my lord, ultimately, what I'm let us give it to the plaintiff, my lord. It is okay. Since I should have also objected, I should have also come before this honorable court at the trial stage, my lord. Objecting to this. I should have come to the High Court. This cannot be done. This was allowed to become an evidence.
This order was passed when? That
20 October 2009, my lord.
This is a part of the court record or just?
Yes,
separate?
this will be a part of the court record because it is a certificate issued by the Civil Judge Senior Division in title suit number 2 of 2004.
And then the decision was also the,
And this was passed pursuant to an order passed in the trial, my lord. That is order dated 25/8/2009.
order passing,
Order passed in the suit
25?
25/8. Wow. 25/8/2009. It is as per the certificate. Yeah, is it there somewhere? Of the paperwork, part of the paperwork? No. No. Where did you get it?
25,
25/8/2009. In the title suit 2 of 2004.
was order passed by civil judge.
Civil Judge Senior Division. Dimapur.
And then basing on that, this order was passed by the which we have read.
I just read, madam. This is
28,
also, this is a certificate issued by the Civil Judge Senior Division.
But that was also by
Yes.
senior division
Yes, madam.
himself.
Board, yes, madam. Himself. Worship, this may be a challenging case, but my lord,
This record, if it will be difficult to find out. And because this, to link with this, probably it will be difficult now.
But what to do, my lord? Somehow we have to deal with this, my lord, now.
Okay.
Now, lordship, but after lordship, anyway, my lord, as I conclude my argument, lordship, things will be little easier, I suppose, my lord. Lordship, then lordship has seen the my cell lead. Then lordship I apply for mutation, my lord. Kindly come to my pata, my lord. Yeah. 194. Paper book. Paper book 194 page. Lordship. Lordship.
Yes, just a moment.
Do you have any receipts from them? After exhibit this was cell lead was my exhibit. D1, my lord. Cell lead was D1. My cell lead was D1. Page 194 is exhibit 2. Lordship,
Salary.
Lordship, salary
Salary
is
is
page
189.
189, that is D1.
This one,
Lordship, the next one is page 194. This was exhibited and proved as D2.
one 194.
194. This is the pata, Jamabandi. The records of rights, madam, of the land, of my land.
This was issued on.
This was issued on Lordship 2186, right? And Lordship may kindly see whose name was there prior to me, my lord, that Changkongse Hansing.
This is called, 194 is called.
It's called Jamabandi. So Lordship, may I pause here again for a moment? Earlier in Dimapur, this was treated as, this is the entry in the records of right register. And they give us a copy. And this copy is also maintained in the revenue office, district office. And then, my lord, this is, in Dimapur, this was used as the pata. Now, in lieu of this, they're issuing a pata book. But that is very recent. That's a recent development. Before this, this was the pata. This is the entry in the records of rights, where all the land, cadastral lands are.
Now what is used?
Huh?
This was used as a pata.
Yes, this was the pata.
Now,
my lord, they're issuing a pata book, a red booklet.
so this is in your name.
This is in my name, before my name, my lord, the one which has been struck off. Chang Hanse Hansing, my lord. Lordship has seen the defendant number 4, just above my name, my lord, in the first column.
Yes. Sir.
That follow the other, my predecessor interest, that was him, my lord, clearly marked out. Then Lordship may kindly see the dark number also 172, an area which totally tallies with what I'm saying. 1 kata 15 lectures. Then Lordship may kindly come, area again 1 kata 15 lectures. Lordship, this is important. Mutated white in the remark column, column number 10. Mutated white, M means mutation, M-154/85, my lord. Dated 4/12/85. Issued on 2186. And Lordship, this tallies with what has been stated in page 30, that letter dated letter of 2003. 31, page 31. 4/12/85. This tallies with what has been said. So this was there in the revenue records, was undisputed. My land, the land was in my name, and before that it was in the name of one Hansing. It is there in the revenue records, Lordship. And Lordship, may kindly again recall, my lord, the other day I had briefly pointed out that The plaintiff themselves say that from 1968 onwards, the area became a cadastral area and pata system was introduced. But they did not have pata. They got the pata only on the basis of an allotment order, which was found to be incorrect, wrongly given over a land which was already held by me. And therefore it was cancelled. And because of that cancellation, the suit has arisen. The dispute has arisen. What has happened is, my lord, the land after my purchase has been lying vacant for a long time. I could not attend to it except for constructing a brick wall. And therefore, my lord, finding that the land is vacant, some documents were sought, allotment was sought to it. Without proper verification, the land was allotted to the plaintiff. And subsequently, when the government found out that no, the land is already in somebody's name. And when that was cancelled, my lord, she filed the suit.
This is Jamavandi.
Yes, my lord.
Is there any other document?
Then lordship may kindly come to the 202, my lord.
This Jamavandi was issued on which year?
My lord, it's clearly mentioned 2186.
2186 was issued. Name
Yes, my lord.
86. So, so after this, then,
After this, lordship may kindly come to page 202 to see that land revenue 202. Lordship may kindly come to 202. This was also my exhibit D4, my lord.
no, this Patta has been exhibited as
This D2.
D2.
My
So
document.
where do we find the, 1997,
Which one, my lord?
exhibit?
98, page 98. Huh? Exhibit, my lord. Defendant number 3's exhibit. Jamabandi, cell D1, exhibit D2, Jamabandi, my lord. Then D4 also may kindly note, lordship may kindly note D4 also. I'll come to that now. Page 202. High Court judgment.
Yes.
Lordship, then may kindly come to page 202, the exhibit D4.
Yes.
Revenue clearance, my lord. After this is at the time when my predecessor in interest, land revenue, the land revenue paid by my predecessor in interest, Hang Sing, my lord, cleared up to the years 85, because till 85 he was the owner of the land. From 72 to 85, land revenue cleared by Hang Sing, my predecessor in interest.
So thereafter, you also paid.
Yes, Lordship, at page, at the next page, my lord. I had, evidence was taken till the date of evidence, it was, I had taken page 203. No, 203, yes, my lord. 203 is the next one. This is my payment, my lord. Up to 2006, I've been clearing the revenue. Even after the dispute, my lord, I've been paying. So.
This is from to
Lordship, is 2006. So I've been paying.
2006.
Yes, I've been paying. I paid, and at that point of time, I've been paying.
This is the last.
This is the last at that point of time, my lord, during the trial.
In between.
So 72 till 83, 85, my lord. Then I took a purchase in 85. I've cleared all the revenues still at that month. That was not been an issue.
Okay.
So my lord, so far these are the documents based on which I derive my title. These are my title documents.
So these document, this was exhibited.
Yes, my lord. Exhibit 1 to D1, D2, D4. And the judgment of the High Court were exhibited as judgment of the High Court in writ petition, and the civil revision, my lord, was exhibited as D43. Exhibited and proved, my lord. Lordship is well aware that exhibiting a document itself is not sufficient. It has also to be proved. I proved that documents, my lord.
Yes.
Lordship, then, Lordship, I'll come to that in my evidence I've given. Yes, I've examined only myself, my lord. I could have also strengthened my case by bringing some more witnesses. But at the same time, my lord, because of that, I cannot be defeated, because it is the plaintiff who must prove their case on their own strength. So, my lord, has this plaintiff established their case? So what happened after this, my lord? In 1990, my lord, Lordship, I'll be taking your lordship through those documents. In 1990, my lord, I tried to build a small stone crushing. You install a small stone crushing machine. Neighbors complaint, the foundation made for a stone crusher is still there, my lord. It's still there on the land. That's what my client told me even yesterday. Unless they remove it, because it is in their possession now.
You try to establish stone crushing.
Install a small stone crushing machine, but it's a residential area, my lord. Neighbors objected, so I did not go ahead with it.
You have constructed some.
Then in 86 itself, my lord.
No. For installation of the stone,
Yes,
in the stone crushing, you have done something.
the foundation was made, my lord. Concrete foundations. Lordship, but before that, in 1986, I constructed the brick wall. This is the most crucial part, my lord. in 1986, my lord. Specific pleading, my evidence given, unimpeached, my lord. They have not been able to demolish that evidence of mine. 1986.
Bricks wall, all
Brick
around.
all around the land. Brick wall. I constructed the big one. And I've said from the very beginning, when the dispute arose, this is my land, I've constructed this wall, I'm having this pata, I'm having these documents. On that basis, I've constructed this land. All along from day one when the plaintiff came and encroached the land, because she had already encroached. I stay in Mokshu, my lord. So, Lordship, what happened? May I just narrate briefly, my lord? Whatever I say, I have to prove it, my lord. I have to show it by the evidence. But let me just just to make the picture clear, sometime on 15/5/2003, my lord, while I was in Mokshu, someone informed me that someone has encroached your land. I rushed down to Dimapur and I found out that an order was given, 13 May 2003 order, allotment order. Allotment, my lord. What is allotment, my lord? The government allotting its land to somebody. The land was not allotted to me. I had purchased it from a person. And that person may have been allotted. That's what the record shows. I had to purchase it. So therefore, for me, allotment is not required. For me, pata is required. Pata through transfer. She claims that she has purchased the land, but she entered the land on the basis of the allotment order given by the government, settlement order, my lord. Settlement of land by government giving the land to her. She entered the land in May 2003. When I found that out, I made the complaint. Then they made an inquiry and government said, yes, this land is already held by me and therefore double but the pata has been given to her, cancel her pata. And then she started this suit. When she started the suit was rejected. The plaint was rejected. Wrongly, my lord, of course. The trial court rejected the plaint. The assistant to deputy commissioner rejected the plaint. So they came here by way of a civil revision. At that point of time, and a restraining order was passed. On my complaint, a restraining order was passed. So in the civil revision, they challenged the rejection of the plaint as well as the restraining order. In the meantime, the government, the revenue authority said that has been wrongly issued. Dual pata has been given, so cancel. The deputy commissioner was directed by the revenue authority to cancel by a letter, my lord, which is also part of the records, part of the evidence. That's when therefore challenging that said letter, my lord, they came by way of a writ petition. So civil revision already pending, they came by way of writ petition challenging the direction passed by the revenue authority to cancel for cancellation of pata. Thus, the High Court, this honorable court, took the two petitions together, heard the two petitions together, and by a common judgment order, my lord, which is exhibited by me as D3, High Court says, no, the suit has to be, the rejection of the plaint on the ground that it's not maintainable, go to the revenue authority, that is wrong. It has to be heard, decided in accordance with law. The plaintiff was told that whatever challenge you have made to the restraining order, the letter for cancellation, that you challenge go to the civil court and challenge it there. So they came. And she was also given the liberty to make amendments for challenging the subsequent letter for cancellation. And the deceased cancellation order also, if any. And the DC also passed the cancellation order. Both of them, they amended the suit by challenging the letter for cancellation and the cancellation order. Letter for cancellation passed by the Revenue Department of Revenue, and the cancellation order by the DC pursuant to the direction passed by the Revenue Authority. And so the plaint was amended. Paragraph 22A, 22B was incorporated, and the prayer was amended, and the suit was, that's how the plaint was amended, my son. That was sometime before, suit started in 2004. Now, Lordship, kindly note this. Once a suit is filed, the doctrine of lis pendens is very clear. It says the suit property becomes the property of the court. It becomes the property of the court when the lease is pending, my lord. Doctrine of lis pendens, absolutely clear. Anything you do over that land, you must have court's permission. An inquiry verification report somehow is managed, my lord, not at the court's order. In the year 2005, when the matter is sub judice, when the subject matter is
under the control of the court. Something is done to the subject matter without the court's knowledge, without any approval from the court, without any permission from the court. And inquiry is made, my lord. PW2, who was the land record survey officer, without the permission of the court, plaintiff takes in that report, it says, I was also there. I was never aware of it. All the parties were there. I was never aware of it. I was contesting the case in the court. They say a verification report is done, and that verification report is also used as an evidence. And today, my lord, in this hearing, this report has been referred to again and again and again, my lord, page 86, which was done during the matter was sub judice. Without the permission of the court, an inquiry was conducted. They say it was ordered by the deceased.
There is no court order for.
No court order, my lord. And they say it was done at the instance of the deceased order. Where is the deceased order? It's not an exhibit. And the person who passed the verification report, he says that it was passed on the basis of a survey report. Survey is never examined. Trace map people by survey, trace map not exhibited, survey report not exhibited, surveyor not examined. And in the report itself, my lord, contradiction, my lord. Small discrepancy may not be fatal. Contradiction is fatal, my lord. In the verification report, which is exhibit P17 of the plaintiff, he says, this verification report is prepared as per the survey report. Categorically, page 86, Lordship, may kindly see it, 186. And this was hammered again and again to impress upon this honorable court that they have a title. That this is their land. This is P17, right? Lordship, pay.
The suit was filed in the year 2000.
4. Verification report dated
Of 2005.
5. And Lordship, may kindly see verification report prepared by one Pusal Nagi, who was the that had not been sent by the court, sent by the authorities to testify. And he also says, my lord, that this document will not confer the plaintiff any right. He also says this in his examination, in his cross-examination. And Lordship, kindly see second paragraph. As per the report, see in his plot. As per the report means survey report. Listen, what is this, my lord? What is this? A verification report? On the subject cited above, I have the honor to forward herewith a survey report. He's forwarding a survey report, and he says, as per the report, he calls falls within that number such, measuring such, under her physical occupation. Yes, my lord, I've been ousted from the possession. She occupied her land. She doesn't want to go out. Now she has taken me into litigation. I was dispossessed only in the year 2003, my lord. Dispossessed only in the year 2003. Then, obviously, in 2005, she has already occupied my land illegally. And the land belonging to Sri Apung Ponganer falls under duck number. Some duck number, she says, my duck number is not this. The same plot may have different duck numbers also, my lord. Wrongly, erroneously. But I was the one who was prior in point of time given that Jamabandi, not her, my lord. With an area of 1 kata, 15 lechas, which is currently under the occupation of Wabang Jamir. From where did Wabang Jamir come? My lord, I do not know even who is this Wabang Jamir. How can my land be occupied by Wabang Jamir? I don't know who is this Wabang Jamir, my lord. They have not produced this Wabang Jamir in the court, my lord, to say, yes, I'm holding a certain plot of land and this land belongs to Apung Pongon. No, they have not done that, my lord. And as per the trace map submitted by Sri Apung Pongon. Now what, my lord? On what basis they're saying? I've submitted a trace map. To whom? To Pascal? Why should I submit a trace map to him, my lord? And that, as per that report, as per that trace map, I'm holding the land, someone else is there. Now, my lord, it was based on the survey report not exhibited, survey not examined. What value will this have? And the plaintiff wants to impress upon this honorable court on the basis of this letter. And the person maker of this document itself says this will not confer the plaintiff any right, confer title. This fellow, this officer himself has testified in the, he has come on his, he was a plaintiff witness. He has come to testify on behalf of the plaintiff. And says that this will not confer any right.
The plaintiff was given allotment on in the year
2003, my lord.
or
15,
2003 only.
15. Settlement order 3/5/2003. Jamabandi on 13/5/2003.
No, settlement on
3/5/2003, my lord, page 169, exhibit P4,
page 169.
169.
3/5/2003.
My lord, 1303, this is 1303. Lordship, kindly,
169.
let's clarify, my lord. The date. Yeah, exactly. Why, huh? Yeah, yes. I think the date is not very clear, but it's 13th, my lord, 13/5. 13/5/2003. And Jamabandi? Huh? Jamabandi issued on, again, 13/5/2003. Jamabandi also issued on 13/5/2003, on the same day. And on the strength, and lordship, may I kindly come to this document, my lord, page 169, Jamabandi page 170. It's also not very clear though. Lordship, a better copy is at page 17, my lord. Lordship, may I kindly refer to page 17 only, not
17.
17. Hereby allowed to settle, settlement, my lord. Very clearly mentioned, settlement, not mutation, my lord. If it was a purchase, then it should have been a mutation. Government cannot settle somebody, purchase land. All the government can only settle the land which belongs to the government. So the government thought that this land is government's and will allot her to her. That's because that is the application made by her. She asked for allotment. And the other stories are all concorded, my lord. She found the land vacant.
And you lodged complaint?
Lordship, I'll come to that, but first this one.
Okay.
Then Lordship has seen this is a settlement, not a mutation, my lord. If I purchase my land from my friend, then I will ask for a mutation to transfer the name from her to my name. And so there is no requirement for a settlement order. Only mutation order and the transfer of name in the Jamabandi.
So now it should have been according to you.
If it was purchased, my lord, it should have been mutation. It should have been, but the Jamabandi should have reflected that it is mutated. Now, what is reflected in the Jamabandi, Lordship, may kindly come to page 19, exhibit P6. This is exhibited as P6, page 19, my lord. In the remark column, my lord, in the column, my lord, pata number is given 1099. No one is there, my lord. T. Morris' name is nowhere shown, like it was shown in my case. Then Lordship, may kindly come, but let's go to the last column, my lord. Area 0B2K16LS approved by government order number such.
That means in your case, Hansing's names was
Yes,
reflected.
yes.
In this case, his Maurice's name should have been reflected.
Should also have been there, my lord. The same office maintaining the same records, my lord.
So Murray did not have the pata.
Did not have the pata. That's why Murray did not have the pata. Then Lordship may kindly come also. How did she enter the revenue records? How did her name enters? On what basis her name is recorded in the revenue records? Remark column explains that. The remark column clearly says an area measuring 2 bikas, 16 kathas approved by government letter number such dated Kohima, April 2003, and this is order, Lordship, yes, this is order number such dated, my lord, 13 May 2003, the settlement order, 13 May 2003. So therefore, on the basis of the settlement order, this pata was issued. Lordship, Lordship, am I clear? This Jamabandi, this pata was issued to the lady, the plaintiff, on the basis of the settlement order, not on the basis of purchase. Her case is of purchase, my lord. But the pata is issued on the basis of settlement, not purchase. Contradiction, my lord. In her documents, in her pleadings, in her evidence, and in her pleadings. Fatal contradictions. And
So if it was purchased land, then
yes,
pata should have been issued. But then this was.
pata
issued-
should have been issued on the basis of mutation, my lord. This was issued on the basis of settlement allotment. These are documents produced by the plaintiff to establish her case, man. Her own documents. Not the documents of the state respondents, my lord.
But the plaintiff was issued.
Pata on the basis of settlement or oblique allotment. Government giving their land, allotting the land, settling government land on behalf to the petitioner or to the plaintiff. Somewhere we will get caught, my lord. Somewhere else. Sometime, every time we will get caught, definitely, my lord. We cannot manipulate everything.
Okay.
Now, lordship.
Yes.
No, lordship. So, my lord, remark column clearly shows that. And my lord, she paid land revenue when? Kindly come, my lord. If this land was there, if it is a cadastral land, like we did, my lord, like my predecessor in interest did, from the moment I occupy this land, I have to pay land revenue. She pays only in 2003. Only after this allotment. Only after the pata is given. Timore was not paying any land revenue. Next page. Huh? And that is P7, my lord. Exhibit P7, page 20. Now, these are facts only, my lord. The substantial question of law address, my lord, and then everything will become clear. Absolutely clear and simple. Now, lordship, based on these documents, my lord, these are the documents on which she is claiming title. So for her, these are the document title which confers her title. And based on this document, my lord, she came to the vacant plot of land which was there. Lying there since 1985, vacant. My lord, I cannot do anything. I stay somewhere else. All I could do was fence the wall, fence the land, go back, try to open a small stone crusher unit, objected. So I could not construct a house. I'm staying in. I'm not, because of my financial difficulties, I'm staying there, my lord. I'm staying somewhere else. The plot is lying vacant. Documents are prepared, my lord. Enters the land. And I'm unable to evict. So what I do, I make a complaint, my lord, to the revenue authority. Page. 11, go to Asinobi Mama. I make a complaint, her document will let it by where was I? She has also exhibited that. Somewhere it is there. Okay. Anyway, it was there. It's complaint dated page 53? No, complaint dated 8/5/2003. That's all we have said. It's not there. So I had made a complaint on 28/5/2003 to the Deputy Commissioner Dimapur, my lord, which is not a
When close complaint?
28/5/2003. In my pleadings, lordship will find.
2003.
2000, yes, 28/5/2003.
Page,
Lordship, that document is in my pleadings referred but not annexed, my lord.
meaning where?
Lordship, only my WS. Huh? 33, and then just check her additional, whether she also says that. She also says it, huh? What is the page number? What is what date I said? Date 25/5. 28/5, right? Worship, may kindly bear with me, my lord. Yes. Okay. All right, this is not here, but in our pleadings. Where's our WS? 30? 33. Mm. 25, what, 28 Tashana, Sanogina? 28/5/2003, yes. Lordship maker, that was in level. It's annexed annexure 3. It's not like it's annexed, it was annexed. Lordship, it is there. It is there. Yes, Lordship, may kindly come to page 51. This was my annexure 3 to my WS, my lord. He also clearly said, my lord, everything, whatever I have been submitting now, I bought it from J. Hansing. Then, my lord, Pata was issued to me in 85.
2003.
Yes, my lord, page number 28/5/2003, my lord.
Yes.
My complaint to the Deputy Commissioner. Illegal encroachment over my land, my lord, measuring. And this is, then, my lord, that I purchased the plot of land such and such. Should I read this or it's not necessary, my lord?
This is same.
Lordship?
Yes,
This is the complaint made when I found that she has encroached my land. Should I read this, my lord?
Let us read this.
Okay, Lordship. To the Deputy Commissioner, my lord, illegal encroachment, unauthorized construction. Okay. With reference to the above, I take this opportunity to draw your kind attention and make the following submission for your kind perusal, information, and necessary action. I have purchased a plot of land measuring 1 kata 15 leches from Sri J. Hansing, covered by Pata number 70, dock number 172, block number 9 of Dimapur town. That the seller was the owner in the records of rights of revenue department, my lord. That is also reflected in the documents. And the sale was completed by sale deed duly registered by sub-register Dimapur, bearing number such, dated 1785, my lord. I registered it, paid the stamp duties, unlike the plaintiff. That with the registration of the sale deed, the ownership was totally and absolutely vested in me, free from any encumbrances. That on application, the said land was mutated by mutation case number such, dated 4/12/85 on 21/86. And accordingly, the pata was issued in my name in replacement of the seller C. J. Hansing. That up to the date, land revenue has been paid by me to the appropriate authority. The said plot of land was duly bounded by me at my own cost by brick wall, lordship. I've clearly said that in 2003. that I am ordinarily a resident of Mokchung and taking advantage of my absence, it is now seen that one Srimati Lirini Kikon encroaching upon my land and put up a board claiming my land to be herself and has constructed a small house thereon after destroying and removing my security wall. Then that her action is absurd, Lordship. Thus, now, Lordship, what has happened? She took those, she prepared those, she somehow got those papers, my lord, that entered the land. Now, Lordship, this is 2003. Lordship, a very pertinent point of note, my lord. I have been speaking about my boundary wall since from the initial period. The brick wall, my lord. The brick wall will not fall from heaven. Somebody has to construct it, my lord. All along, to show that I was in possession, I continued to say, I built this. Now, Lordship, may kindly see whether there was a brick wall or not in 2003. Lordship may kindly come to that survey report, which the petitioner is relying, which the plaintiff is relying as exhibit P14, my lord, page 31, my lord. Huh? No, 17, right? 17, right? Huh? You said 17? Is it this? No, this one also same thing. Let's refer to this. This cell date, right? This is survey report. Same thing, right? Yeah. Right? 2002. 2002. 2002. Which page? Yeah, this one. 166. Lordship may kindly come to page 166. Yes, 166, Lordship. Huh? Lordship, this was exhibit P2. Lordship may kindly read. Lordship, I'll just take a minute. As direct survey report. So what they did, madam, when an application is made by the plaintiff to allot the land to her, a survey is conducted, and the survey says, as directed by the authority by order number such, that the 16th September, I have done the spot verification with applicant, my lord. Applicant, there's an application by the plaintiff. Srimati Lirini Lotha and elders, with elders, assisted by neighbors of the plot, which is situated at block number 9, Duncan Basi, near SBI Bazaar branch area of 2 Kata 16 lectures. Lordship, the dark number is not given there, it's just a block number 9. The land in question found brick walled fence and vacant within the plot, my lord. It is says, when first went also, the land is already bounded by a brick wall. An application was made for allotment. The surveyor goes along with Lerini, my lord, the plaintiff, and they found the land vacant, but brick walled by brick walled. The plaintiff never considered. Lordship, in her pleadings, because it is a suit, my lord, pleadings is very important. No evidence, no matter what kind of evidence, unless there's pleadings, my lord, no evidence will help the plaintiff, unless there's pleading, settled law, my lord. In the pleadings, my lord.
This survey report was?
Time.
Okay.
Yes, Lordship. Lordship's question, my query.
Survey report
Yes.
was prepared on the basis of?
Application made by the plaintiff.
Okay. This is after?
This is before, my lord, before she was allotted. She was allotted. This is in the year 2002, my lord.
Before allotment, the
Yes.
existence of the brick wall
Was there?
reflected.
Yes.
So despite of having the brick wall being constructed.
Yes.
Okay. So at 2, I have summary again, there DB.
All right, ma'am.
With Tanaka.
Oh, I see, ma'am. I see. So, Lordship, that means today your Lordship will not be able to continue.
So because at 2.
I understood, my lord. Difficulties, I understand, my lord. Lordship's difficulty, I understand.
Then what to do?
Lordship, kindly continue this on Monday.
Monday.
No, that is okay. This is part-heard matter. Fixed item is different. This is a part-heard matter.
So your senior can come on Monday or Tuesday? Tuesday.
I have taken instruction in that regard.
Okay. No, we'll fix on Tuesday.
No, Lordship, fix it on Monday. We can continue to Tuesday also, my lord. So, Lordship, see, Lordship.
Monday.
Lordship, what I'm saying is, Lordship, here also, we have not finished my part. Even,
yes.
not gone into,
It
we'll
will take
take,
more
we'll
time,
take
I-
again.
Longer time.
Yeah, so let's start on Monday, my lord. Because Lordship, Lordship is leaving on Friday. This term, this roster, my lord. So Lordship, we should not take it to, should not take it beyond Tuesday.
Yes.
Obliged, my lord. Much obliged for the patient hearing, my lord. It's challenging, my lord, no doubt, but somehow we all have to deal with this, my lord.
Mr. MT Longzo. Land Council for the respondent number 1. Mr. You are Mr. Who is also present on behalf of the petition, applicant. Staff. List this matter again on Monday
Monday, my lord, that's
for further hearing. Okay.
obliged, my lord. Highly obliged.
The book will be recorded on Monday, no?
Yes,
Book list that you have
yes,
to
yes.
send. Already,
The same books.
kitab kan tu ini Rakibe.